This is the testimony of Jose Torres, a key witness in this case because he's an eyewitness to the shooting. I want to bring in Mike Koribanics to talk a little bit about this. You're a former prosecutor. You're also a defense attorney, so you're the best guy to help break this down for us. So obviously this case, we know a huge part of it is that dash cam video. And then we saw, I mean, just hours and hours of going through police reports. This is a very document-heavy case. So what's the value of an eyewitness like this? Is this one of the linchpin witnesses? Is this really critical to the case?
I think it is. I think it is for a number of reasons. Sometimes videos, although they appear to tell us everything, that a case like this is all about perspective and context. And this just gives us another perspective and a little different context. I mean, here's someone who's really got no axe to grind, has no horse in the race. He's an independent witness, which is always the most dangerous for a defense attorney to deal with. I just think it's a little interesting here, though, the exchange between the judge and he. Twice she sustained objections, which I really didn't understand why, because they were based on his observations. And I also thought it was a little unusual for a judge in a bench trial to be doing that, because she's the one who's deciding what's relevant and what's irrelevant. So to do that, it seems like it upset him a little bit, too, because he was thrown by it. It almost looked like he felt like he was being reprimanded. And I just thought it was interesting that back and forth.
Yeah, Mike, you make a good point. He did seem a little bit like, oh, sorry, I didn't know there wasn't an open question on the record, and the judge, I guess, trying to keep this streamlined. But more on that and the impact of what the bench trial means, I definitely want to break that down with Mike today. Right now, we're going to continue with Jose Torres' testimony on the stand again. This is a witness to the shooting and one of the most important witnesses to the prosecution. Take a look. This is Jose Torres on cross-examination, really holding his own despite being pressed by the defense attorney. I want to bring Mike back in to talk about this because I thought this was some of the best stuff in this trial so far. Obviously, the defense attorney taking him to task on the reliability of his account, which you generally see. And something else I thought was interesting is making that distinction. The person you saw on TV, who you say is lying, is not really one of the people that was at the scene. Do you think that was effective with the judge?
You know, and I'm glad you said with the judge. This is
That's an important point, right, yeah. Mike?
This is just very different, this trial. It's a very serious case, and there's no jury. And a judge is deciding, and basically what a judge is doing is wearing two hats, finder of fact and finder of the law. And some of the things, as he was asking the questions on cross, I thought were things that a jury may not be so inclined to favor the defendants on. I mean, here's a guy who's in a car, he's minding his own business, he's really got nothing to do with this, and this whole life-changing event happens in front of him, yet he thinks enough, and it offends him enough by whether, I mean, how does he know a PBA spokesman, a union? I mean, that's like sort of really makes a moment with this witness, but I think he's a tough witness, and I don't think they scored too much on cross-examination with him.
Yeah, I think so. We're going to continue to watch it, and that's a great point. I mean, he's a layman. Why would he know who was making that announcement as opposed to one person to another? So I think that he really, as Mike said, he came through on cross and held his own. So let's continue to watch his testimony. Again, some of the most important testimony for the prosecution. Take a look. I want to get Mike's opinion on this one. The witness saying, hey, defense attorney, you're really cherry picking the moments in my answers, and it's not quite accurate. Mike, what do you think about that exchange we just saw?
I think the witness was right, and I'm a defense guy now, so I
won't tell.
Because I've done those things so many times, and I've had judges say, Mr. Koribanics, let him finish his answer. There's a rule of evidence that I'm not so sure about in Illinois, but the doctrine of completeness. We're not there to trick witnesses. We're there to ask questions. Now, he was explaining his answer, and I think the judge, once again, should have let him explain his answer.
Yeah, it was interesting that she actually cut it off in the end. I was a little surprised by that, too. And I also think that witness really had the gall there, right? I mean, he did a great job of saying, that really wasn't my testimony.
And that's what I think would be so impressive in front of a jury is that he's there with he doesn't have a civil suit. He's got no interest in this. Yet he is so offended by what the police said and he witnessed. I think this is huge for the prosecution, and I think this is great proofs for them.
Yeah, I think it's a really good, I agree, it's a really good witness for the prosecution, and only time will tell what the judge is going to think about all that, because again, we're in a bench trial here, so a little bit different analysis about the impression of the witnesses as we move forward, which we will break down with Mike. In the meantime, we have to go to a break, but make sure to stick with us. More on this trial when we come back. This is Officer Gaffney's partner on the stand with some critical testimony of his observations on the night McDonald was shot. Mike, I need your take on this and help me break this down a little bit, because this isn't Van Dyke, who was the officer who shot McDonald, already on trial. That's over, convicted. Now we're talking about the conspiracy, obstruction of justice, official misconduct. How is this testimony fitting in? There's a lot of focus on the knife, how far away the officers were from McDonald. Is there a lot of focus on whether or not there was a threat? Is that what the crux of this is?
Well, yeah, I think you really can't look at any of the testimony separately from the previous trial. I think, yes, what they're basically coming forward is saying this witness is very key, and this was a situation we had under control. Nothing would appear to be going haywire. Actually, what rung in my ear was the beginning when he first comes and confronts the suspect. He sees he's only got a knife. The hands are out. He sees what's going on. Things are under control. He's acting along with his partner at this point in time, very calculated, waiting for the taser, just following, observing, saying he's turning around, showing his hands. So nothing seems, I don't remember the word that Torres used when he heard the spokesman for the police department, but say crazed, words to that effect. Nothing seems crazed here. Nothing seems like anything in the report would reflect something that was out of control. So that shows they're setting up the conspiracy and how these false reports, which were in such contradiction to what was actually going on, in my opinion.
Yeah, Mike, I think you're probably right, because that's really what this is, right? Those reports are supposed to be a contemporaneous account of what's happening at that moment, because memories fade as time goes on. But now, when you get these officers on the stand who also saw what was happening, they're not really sounding like, oh, there was this crazy situation that required force. So certainly that's what the prosecutors are trying to pin down. Now, we do have to go to a break, but make sure to stick with us. More on this exciting trial coming up. Officer McGillicott, defendant Gaffney's partner, on the stand. I want to bring Mike in, defense attorney extraordinaire, to talk a little bit about this. I think I know where the defense attorney's going. There's a lot of talk of, okay, so you talked to Officer March, his client, separately from another officer, separate from this other person. Can you explain to our viewers, what's the purpose of making this distinction?
Well, I was actually smiling while they were asking that, because so many times with clients I defend, that's one of the first things when they pull a car over is they separate the occupants, ask them immediately thereafter their version of where they're going, what they're doing. And quite frankly, that's where you see who's telling the truth, because if those stories conflict, then you know something is amiss, something is not right, and there may be need for further investigation. In this instance, it's, you know, it's just a little ironic as to how they separated these two police officers to see what was going on, and how he is now trying to distinguish between the two of them and what their roles were.
Right, and a special attention paid to what was March doing this whole time. And obviously this is his defense attorney who's doing the cross-examination and is very clearly trying to isolate him from any sort of coordinated agreement to prepare reports or whatnot. I think we can see where the defense is going. But let's keep watching and see what happens in this next part of this very critical cross-examination. Take a look. Basically a minute-to-minute account of what Officer McGillicott saw on that night. Mike, I want to bring you in because, you know, I'm a little confused here. And I think part of it's because there's this focus on the knife. He turned around. He used the knife to pop the tire, face the partner. He sees him on the hood. I mean, the way that this is being explained by the defense attorney makes it sound a little bit intimidating, right? And could that possibly be an argument they're going to go for, that, hey, look, while the dash cam reflected something different, it was an intense situation, and it was recorded that way in the police reports because of that. There was a knife involved. No one's contesting that fact.
Well, I think what they're trying to get here in a defense, which is really helpful in their defense of this case in terms of false statements, false police reports, is that these were actions that people can interpret differently, but they were actions. The tire, how one person interprets the stabbing of a tire and how another could be two different things, especially police officers from their various vantage points and in the context of where they're standing. So I think they're being effective in that part of the defense because they're trying to show that there were no blatant lies here. Maybe some misinterpretations, maybe some mistakes, but nothing that arises to action that was criminal.
And that's what the crux is going to be, right? Because taking this, now you have to go to the documentary evidence. Is the documentary evidence more important than this witness testimony?
Well, I think what's going to happen is they're going to come together for the perfect storm. Hopefully the prosecution's going to point out that, you know what, regardless of what they interpreted, this is what they wrote, and some of the things they wrote were totally an opposite to what was happening. I don't know if they're going to be able to accomplish that after hearing some of this testimony. It's going to be a difficult road.
Yeah, it is going to be a tough road, and especially if we're not sure what else is going to come, but all of those police reports were obviously very important. There's also some emails that may be at issue. Only time will tell what the court is actually going to see. And all this with the backdrop of a judge. A judge is the finder of fact. So the defense laying the foundation for what is sure to be the arguments that they'll focus on in their close. We do have to go to a break, but more when we come back. There's a lot more to break down before court is back in session tomorrow. So this is the opening statement for defendant Thomas Gaffney. Now, Mike, we heard this opening statement. Additionally, something we didn't cover earlier today, the defense is split. So these defendants are being represented by different attorneys, even though they're on trial at the same time. What do you think the reasoning is for that?
Well, this is almost in all the cases like this, a conspiracy and things of that nature, you're going to have separate counsel because everybody's got their own interest. There may come a point in time where somebody says, well, if it's really, you think it's my fault, it's not really my fault as much as it's the other guy sitting there. So everybody needs to be protected, and you can only, really serve one master in this instance. So there's only one person you can look out for their best interest. To represent more than one would present a conflict for the attorney because you'd have to pick and choose what defenses to use. Right.
And that's why we see these individual opening statements. Now, let's listen to the defense opening statement for Officer Marsh. Take a listen. All right, 3 different attorneys, 3 different opening statements, many of the same themes, all of them making the point that the evidence that we're going to see at trial is not going to fulfill the burden of the prosecution. Mike, I want to bring you in. There's something I thought that was pretty interesting, and this is the attorney for David Marsh. That was the second set of openings that we listened to. I was getting a little bit of a flashback covering the Van Dyke trial back in the fall because there was a lot of talk about Laquan McDonald, what Laquan McDonald was doing that night, that Laquan McDonald had broken the law, detailing alleged offenses that he committed before he was shot. That was a little slightly different strategy by Marsh's attorney than the other 2 attorneys. Why do you think that was important? And also, side note, the jury didn't really buy it last time. So was that a tactical error?
Well, I don't know. It's always so different when you're in front of a judge as opposed to a jury. I mean, for your client as a defense attorney, you need a unanimous decision of all 12 jurors. And if you just get one juror to see your point of view and create reasonable doubt, you're at quite an advantage. This is really an all or nothing situation with the judge deciding the facts and, deciding whether or not there is a meeting of the burden of proof of beyond a reasonable doubt. I think one of the things this attorney was trying to do was say, Judge, even if my client made some mistakes or did some things in his report, let's look at the whole picture and see that, there was a guy out there who was very dangerous. So any mistakes they made or anything they did is excusable. I don't think that works very well with a judge.
Yeah, it's a little trickier with a judge. Different audience. Got to know your audience whenever you're a trial lawyer. Right now, we do have to go to a break, but make sure to stick with us. We'll be back with more on the cop cover-up trial. Dora Fontaine, some of the most critical testimony in the Van Dyke trial and critical testimony in the trial that we're watching and covering right now, scheduled to resume tomorrow. Mike, I want to get your take on this. So a lot of breaking down. Did you see him draw a gun? No. Was he shot while he was on the ground? Yes. So these are the types of questions that the prosecution is pulling out of Fontaine. Is this more of what we discussed before, trying to lay that scene out, that there was no threat, really almost relitigating an issue from the previous trial?
Yeah, I'm a little surprised that this witness isn't a little better prepped, especially since it's her second go-around with testifying. I think, based on the evidence we've heard before, what the prosecutor's trying to get out from this witness is that he never tried to get up after he shot the first time, if you compare it with the testimony of Jason Torres. They were trying, when he was being pressed on cross-examination, he was like, I never said he was trying to get up. They tried to infer that. They tried to force me to say that. So I'm a little surprised that this witness, being a police officer who was trained to testify, and there's nothing wrong with the prosecutor or defense witness preparing their witness. They should tell them to tell the truth, but here's the reports. Do you agree with this? Do you disagree with that?
That was the testimony of Dora Fontaine. That's her direct examination. Now, I don't know if we're going to get the chance to go through it, but she did face some pretty brutal cross-examination later that week. Mike, let's talk a little bit about this. So, obviously, she's telling her story. Her testimony was absolutely critical in the Van Dyke trial. She contested a lot of the facts that were memorialized in those reports. Obviously, the jury bought it, right? Because Van Dyke was ultimately convicted. Now, we didn't get a chance to watch it, but the focus of the defense attorneys, and this is specifically March's attorney, he was very, very inquisitive, let's say, about how much she needs her job at the force and the fact that she had immunity and with respect to this. So is that what you would expect to see here from a defense perspective? Well,
I think any defense attorney worth their salt is going to attack the credibility of a witness. What's in it for them? The one thing I always know about immunity is there's a big danger, especially in a case like this, because when you start throwing around the word immunity, you're almost admitting that someone committed a crime. Someone did something wrong. So if you're saying that she got immunity, that means something was awry, something was not right in those police reports. It seems this may be the wrong witness to do that with, because I don't believe she authored any reports. She just came forward when the reports were put there. So you better watch how much you want to put on the immunity, because people are going to associate with her. And, you know, you're judged by the people you hang around with.
Yeah, they always say that. Hang out with dogs with fleas, you get fleas. So that's always a major concern in the analysis of how to approach a defense in a case like this. We do need to take a break, but make sure to stick with us. More on the cop cover-up trial when we return. All right, this is Joseph Privetti. He's a witness talking about the police reports, which are obviously a huge piece of the puzzle in this trial. Now, Mike, I want to bring you in on this because usually in a trial, when the records guy gets on the stand, there's a little bit of a, you know, it can be some of the more dry testimony. Here, we have hundreds of documents that are at issue, and Privetti is now going through and explaining what all of the notations and what it means, right? That he's telling us what these police reports say.
This is a very complicated issue from an evidential standpoint. I think this will be something that, if this does not go well for the defendants in this case, something a higher court will have to look at. Because basically the difference here is this is a little more than just a business record. These have defendants who have a constitutional right to confront their accusers, but they are the authors of those documents, which makes it a lot more difficult to put into evidence. I'm not so sure if these are admissible, to be quite honest with you, because these defendants' statements. I don't know if they're trying to get them in under admission against interest, then it may be able to come in, but this just opens a Pandora's box of evidence under the hearsay exceptions, where public records are allowed in, but not necessarily if they're by law enforcement who observed the event. But in this manner, they may be trying to get them in under actually a declaration against interest, and that's probably why he's there. But his explaining what they meant, I think, is very, very dangerous water to travel on.
Yeah, that's interesting, Mike. And I think if I were in the prosecutor's shoes, that's exactly what I'd go for from a hearsay exception, admission against interest. But how does that really play out? As you said, they're the authors. And if I'm the prosecutor, I'm going to argue, well, they authored these reports and there's inconsistent there's testimony that's inconsistent by other eyewitnesses. They should come in. Because that's the whole point, right? The whole point of this case is these reports are false.
And I think, this is chess when you're here. It's not checkers, it's chess. And maybe what the prosecution is trying to hope for is that the admission of these documents under any rule of evidence in Illinois will force the defendants to take the stand. Although they have a right not to, sometimes now they're putting the defense in a little bit of a precarious position because they've got to decide, are we in a spot now where we have to waive our right to remain silent and have to explain these documents to this judge?
Right, and so that would be more about the intent, right? So you're in a pickle as a defense attorney because you have these documents that say what they say. And then your client, if your theory is that the documents are accurate, who else is going to say what they meant when they wrote it?
That's right. If that's going to be, if part of this defense is going to be, I just incorporated what other people told me, then somebody's going to have to take the stand and testify as to that.
Right. Otherwise, it would be assumed that it was their own observation. So we're going to continue with Perfetti. Again, more on these police reports, which are a huge component of the evidence the prosecution is submitting to trial. Take a look. All right, Perfetti bringing the court through the records that are very key in this case. These are the police reports that are the subject of this matter with the three defendants. Now, Mike, we were talking about this a little bit, and just so our viewers understand, he's not saying what he believes these to mean, Perfetti on the stand. He's really reading them into the record because every profession has acronyms, has notations that mean something, and that's what he's doing right now. He's telling the court what these mean.
It appears that's what he's doing, but there's certain times it seems in his testimony where he's going a little bit further than that, and I was a little surprised one of the attorneys didn't object, at least to.
These are arguments about thousands of internal emails that the prosecution seeks to have admitted at the trial. The defense vehemently arguing that these emails are not relevant. We're going to have a result likely tomorrow morning. That will be the court's first order of business. If the answer is yes, then the prosecution will have another witness coming in, similar, a documents person who will go through these emails. Now, Mike, let's talk a little bit about this. What's the judge going to weigh in determining whether or not these emails actually come into evidence?
Well, I think a lot of it's going to be the relevance of these emails. It appears that almost all of these emails have nothing to do with the three men who are standing trial. It appears they're more like opinions of exchanges between political elected officials who have their own opinions. And basically what they're saying is their opinions really are of no moment because they weren't there, they didn't see what happened. I think this attorney very effectively, though, is using this argument on this motion to get a sense of where the judge is going to go on the sufficiency of evidence, because he keeps speaking about how there really isn't sufficient evidence, and I think he's trying to get a read of where the judge is going to go here.
Yeah, Mike, I think you brought up a good point. Something I heard in that soliloquy when we were making the argument was there's no evidence of a conspiracy.
Correct.
So it's a little foreshadowing. And if these emails aren't between these three guys, then are they really relevant?
I don't think they are. I think all they have is prejudicial value, and they really do nothing to help the case, and I think the judge will be mindful of that since she's the finder of fact.
Right, and that's one of the interesting dynamics in a case like this. There is no jury. Whereas in many cases, it's like, we don't want the jury to hear something that might be prejudicial because they'll never unhear it. Here, the judge is making the decision on what's admissible as well as what the finder of fact, what the jury would normally decide. It's my time to go. Stick around for the Daily Debrief with Aaron Keller. Thanks for joining me. Come back tomorrow.